welcome back. So we are looking at the justification. Okay, we've seen the justification for delegated legislation. So we shall go for reasons against, or the criticisms against delegated legislation, or they can even be arguments against delegated legislation. So these include delegated legislation is an usurpation of the power of parliament to make laws for the nation. So remember, people appoint, or we vote members of parliament to make laws for us. So if these parliamentarians or the members of parliament go ahead and delegate the power to other individuals or other bodies, it's as if their powers is, can I say, taken away. That is what we call usurpation of power. So people criticize it because it takes away the lawmaking power that is accorded to parliament. Again, still, when you look at it in the angle of being, can I say, as these elected members of parliament go ahead and make laws, it's as if they are representing us, or they are making laws on our behalf. It's as if it's us, the electorate, that are making these laws. Are you together? Because if you voted for Chagulanyi as an MP, and he goes ahead and suggests a law, and that law is passed, it's as if it's you as can I say, a person who voted Chagulanyi as an MP making that law. But if now the Chagulanyi and the colleagues go ahead and give power to another individual to make laws, it's as if they take away our rights to make laws. Are we together? Because for example, if a minister makes law, it's as if the minister is doing it out of his own right. It's not us who appoints these ministers, it's the president. So it's as if the executive has a direct control, or it has usurped the parliament's power to make laws in general. Yes, number two, it waters down the doctrine of parliamentary supremacy. Yes, we see that the parliament is the supreme law-making power. You see, the doctrine of parliamentary supremacy. The parliament is supreme, is the supreme law-making power or body. But if these laws are made by other what? They are made by other organs or other bodies. It takes down the what? This doctrine. It does away with the doctrine of what? Of parliamentary supremacy. Then we have number three. It is a negation of the concept of rule of law, as the usual procedure for the making of law are not always observed. Yes, we have always the state procedure. That is, the laws are made by parliament. But if then parliament delegates, it has done away with the real procedure, or the procedure for rule of law. That is when we shall usher in the instances of, imagine a minister maybe dissolving a whole body. A body maybe it's okay. We've seen that ministers can maybe make orders dissolving a body. It's I'll take you back to the first part we saw. How we saw orders usually made by ministers eager to dissolve a public body. So a minister dissolving passing a law dissolving a public body. That means the rule of law is not taking place, or is not taking its course. Are we together? And remember, the minister maybe is doing it out of his own right. Yet it would be maybe the parliament to make a law dissolving a what? A body. Remember, some of the bodies that were dissolved include the custodian board. That was the body that handled the property for the departed Asian. Remember in 1970, 77, 70 something, expelled all Indians. So after expelling the Indians, a body was constituted, and that is the custodian board to handle the property. So the property of the departed Asians. So that body was dissolved later. Okay. Number 4, the control of delegated legislation is inadequate. The control of delegated legislation is inadequate. Parliament has no time, opportunity, or special expertise that may be required to keep close surveillance and make needed objection to administrative legislations. You see that there is little control on this delegated legislation. Yes, after the parliament delegating such powers to experts to make such laws, still even when it's brought back to parliament to be passed, they have little or nothing to add in or to reduce because they are not knowledgeable in that field. Secondly, uh, since there are many laws to be made or parliament is still concentrated on a certain law, they will give less time to critique such a law that is made. You get? So at the end of the day, there is the little control in what? In delegated legislation. And then we also have administrative law makers sometimes have too much power and discretion. For instance, delegation of legislative power to ministers, head of departments, and so forth is often done in phases such as honorable minister deems fit. So they are saying that in this in this point they are telling us that sometimes these people or can I say the delegates, they don't need the people given power to make laws, they are given too much power than required. For example, you see phrases like as honorable minister may deem fit, meaning whatever the minister what will think fit or deem fit. We get? So there is also those phrases like in the opinion of the honorable minister and so on. So it's like at the end of the day, a rule of law will not be observed because it will be just an individual that is thinking, oh, atutegerera fena fena. You get? So those are some of the critiques, and you can come up with others. You will make more research. Mm, uh, then control of delegated legislation, executive control, we have judiciary control. Okay, maybe we can go through this a little bit about we have different controls at different levels. Okay, there is first of all there is this rule against subdelegation. Subdelegation is when someone is delegated to do something and then that person also delegates it to another individual. For example, if the parliament delegates its power to a minister to make laws, it's it will be unfortunate if a minister delegates that those powers to another what? To another individual. So the rule against subdelegation goes as a general rule, a delegate may not subdelegate his or her authority or power or functions to another person, authority, body, or agency. This rule couched in the maxim delegate non potest delgar. So you will encounter this later, so you should quote it like a delegate cannot delegate, or delegatus non potest delegal. So In the case of Attorney General, Bandel State versus AG Federation, the Supreme Court held inter alia, or among others, that two houses of the National Assembly cannot delegate its law-making power, making function, to a committee of the House. So, however, a statute may provide for subdelegation to certain persons and under certain conditions. Generally speaking, a delegate may subdelegate duties that do not involve exercise of discretion, such as. So, before we go any further, first of all, if someone is delegated to do a job, that is a minister, a body or authority, is not supposed to delegate. However, if the statute that gives that body or individual powers to do a certain law or to make a certain law allows it to subdelegate, then that that body or that individual can delegate its power. I hope members are getting me. However, there are those powers that cannot be delegated, and this involves ministerial powers, which includes the signing of letters, memorandum, and instructions on behalf of the person delegating the power. So, as this, can I say the donee? Because we saw the donor was Parliament, delegating its power, lawmaking power, maybe to a minister or to a body or to an individual. Are we together? So the Parliament is the donor, the body is a donee, or the minister is the donee. So this minister also is giving power to another individual to do the work for him. Are we together? And this minister has no powers to delegate. But in certain circumstances, if the law allows him to delegate, he can delegate, but among the powers he's delegating, he cannot delegate powers, including powers to sign. Are we together? Signing of letters or memorandum and instructions on behalf of the person delegating the power. So they can delegate if allowed, but they cannot delegate powers, including signing of letters, memorandum, and instructions. I hope that there you understand me. Then the executive or administrative powers, which involves issuing of license, permit, institution of legal proceedings, and so on. So, if Parliament gives power to the, let's say to a certain individual to institute cases, are you together? Maybe it's the minister or an administrative body or what? That institution cannot go ahead and delegate powers to institute a what? Legal proceedings. It cannot delegate powers involving issuing of a license or a permit. That's why you will always see those permits or licenses. They have to have signatures from the what? From the real person to whom the power was delegated. They cannot delegate such powers. However, a delegate cannot subdelegate the following functions or powers: the judiciary, the judicial or quasi-judicial powers. Okay, a moment, please. So up we've seen, generally speaking, we've seen they can delegate, but they cannot delegate this one. So meaning, even when someone does gives power to someone to do their work, but they will end up signing on their behalf. They will be the ones to issue the suit, to issue a license and all that. So however, these powers, so the lower powers are general powers. Judicial powers or quasi-judicial powers cannot be delegated. Legislative, you will not find the judiciary saying the LOC chairperson should handle cases maybe for murder. You get, those are judicial powers, they cannot be delegated or be left maybe to the bosses, maybe the directors of the company. No, the judicial powers are always have to be, cannot be delegated. You see, however, a delegate cannot subdelegate the following functions or powers: judicial or quasi-judicial powers, legislative or rule-making powers, duties requiring personal performance, and then duties involving exercise of discretion. Where they say, as the minister deems fit, or as so and so deems fit, you will not delegate such powers and say, Fatia, check for me whether it's proper. No, it will be the real what minister or that individual. So yes, wanted to see how these delegated legislations are controlled. However much we are criticizing them that the parliament has little time to supervise over such delegations or such powers, we shall see that these such powers are controlled at different levels. So powers may be delegated by the legislative arm, that is the parliament of government, and may also be subjected to arbitrary use, and thus the need to control and safeguard its use. The three machineries available for controlling the delegated legislation, they are the legislative control, the executive control, and the judicial control. And these forms of these form the subject of discourse. So here they're saying, as yes, as Parliament is allowed to delegate its powers, at a certain point, these powers will be controlled somewhere, including the executive will control it, the judiciary will control it, and the legislative control also, as the Parliament itself will control it. So we shall begin with the legislative control. Legislature may delegate powers to the executive to perform certain legislative functions. In the same vein, it possesses the power to control its exercise according to Lord Coleridge in Heath versus Clark, QBD 391. In that case, it was stated that but delegations do not imply a denudation of power and authority. The word delegation implies that the power are committed to another power, another person or body, which are as a rule always subject to resumption by the power delegating it, and it may and many examples of this might be given, unless therefore it is controlled by statute. The delegating power can at any time resume its authority. So yes, in this case we learn that if the parliament delegates its power to maybe URA to make tax laws, it doesn't mean that the legislature has totally given away its power to make laws on what? On tax or taxation. It means that the legislature, that is the parliament, at any point they can come in and take away their powers. Or if the let's say the delegate, let's say URA, makes such a law that is not favorable and the parliament thinks fit to change the same, the parliament can go ahead and change the same, meaning it has not as in totally given away its power to make laws in such a regard. So legislative control is exercised by the legislature as the donor of the power. It may prescribe that the proposed delegated legislation shall be laid before the legislature for purposes of debating, approving, rejecting it, suspending it, its approval, or amend any part of the legislation. It may also prescribe the procedure to be followed before delegated legislation may be made. The enabling law may require that any legislation delegated legislation made under it be laid before the legislature before the legislation is made as soon as possible immediately after making it. So as we saw earlier that the legislature still, that is the parliament, uh, still known as the donor, has powers to reserve some rights of approving, criticizing, rejecting, confirming, as we saw earlier. So these are all controls that before such a power becomes a law or a delegated legislation become a law, it is aligned or it's brought before parliament for it to be criticized, amended, rejected, and all that. So that still remains a control over what a delegated legislation. Another thing is executive control. The executive exercises a lot of control over a delegate of power under delegated legislation. The control may be exercised by authorizing the donee of the power to submit the proposed rule uh, to the relevant supervisory body, and this is intended to avoid the embarrassment of the government. In addition, the executive, okay, before I proceed to the addition, we see that in some instances, um, there can be a control or executive control where a delegate or the donee, that is the body or the minister allowed to make a law, can be required to put that law, after making that law, to put it before uh, the line ministry to, to see through it or to have a second opinion about it before it is published. Why? To here they say it's intended to avoid embarrassment by the government. So it may not be put down or put before the legislature, and instead it is put before the executive. That is, it will be put before the the, the, the relevant supervisory body. Okay, in addition, the executive exercises such controls through the power to appoint and dismiss an unbecoming donees of power. This is more so when the executive is embarrassed by certain rules and regulations made by a department which do not receive their approval. However, this power to dismiss must be exercised in accordance with the laid down rules. However, the delegated power may be revoked. So, here we see that still the executive may reserve a right to dismiss or to suspend the donee. That is either remember, here it's as if they're talking about a minister. For example, here we see that usually the legislature, that is the parliament, usually delegates power to a minister to make laws, as we saw. But remember, minister is appointed by the executive. Are we together? So the executive exercises its control over delegated legislation by suspending the minister. Are we together? Because it has power over the minister. So, but however, here we are told that such suspension and dismissals should be done judiciously, or should be done in consideration. So wherever a minister makes laws that embarrasses the government, the executive has powers to do what? To suspend. Okay, then we shall proceed to judicial control. Under Article 126(1) of the Constitution of the Republic of Uganda, as amended, the 1995 Constitution, as amended, judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with the law and with the values, norms, and aspirations of the people. So, the truth about delegated legislation is that every subsidiary legislation is at the mercy of the court, which applies settled principles of the for the interpretation of the statute. This is sometimes called judicial review. So, remember, once these subsidiary legislations are made and people find out that they are not reasonable enough, or they are against the constitution, or they contradict the constitution, people have a right to institute administrative review or judicial review to have such a law declared unconstitutional. Are we together? And secondly, when you look at the application, these rules are applied by courts of judicature. So the court can decide to interpret it the way they want. Of course, they have to interpret it in a right way, but it's still at the mercy of the what? Of the judicial officers to interpret such a what? A delegated legislation. So you read through the case of Okoji and others, and Attorney General and many others. So here down we see that courts will normally determine the validity of delegated legislation by applying the test of ultra vires. This is done in the following on the following basis. If such a law is if it violates the fundamental law of the land, that is the constitution, especially, then if the law, if it is not authorized by the Parent Act, still it will be declared ultra vires. If it is unreasonable, if it is vague, if it is subdelegates powers delegated upon it by the statute, once it fails to follow the procedures laid down for its enactment, all those laws will be stated to be ultra vires, and it will end up not being applied law. So it's the judiciary that has powers to do what? To critique the law or to apply the law. So if people go through the judiciary, they can do out or can have the law suspended. Okay, thank you for coming. That's all for today, and I'll be waiting for your questions in case of any. Thank you so much.